This is Justice Done Dirt Cheap in Fredericton, New Brunswick, Canada, August 15, 2012. We're at the Justice Building, and how are you doing there today?
I'm doing okay, thank you.
What's your name?
Sally Brooks.
Would you like to do an interview today?
Yes, I would.
Okay, what would you like to speak of today?
Well, I was back in court this afternoon to observe a provincial court hearing that Andre Murray was summoned to in respect of a bylaw matter. And the interesting thing is, it was a not wearing a helmet on a trail bylaw ticket, and in going through the documents it was identified that the wrong summons was used to drag him into court. When you have a bylaw matter, you're supposed to be issued with a ticket that, well, what it says in the Provincial Offences Procedures Act is it's a ticket procedure, and you're supposed to be issued a ticket, and if it's for prosecution you're supposed to be given the date in court.
Yes.
Now, we know with parking tickets and stuff like that it doesn't always happen because they're issued on the spot. But it also says in that to initiate a court proceeding there has to be a Notice of Prosecution. And
that is the Provincial Procedures Act.
That is the Provincial Offences Procedures Act. Sections 9 to section 16 refer to tickets, and obviously bylaw matters are ticket offences. So basically it says that the Notice of Prosecution should be offered to the recipient to sign, or
yes.
the accused.
Yes.
And if they refuse to sign, then the officer or bylaw enforcement person can endorse it and say refuse to sign.
Yes.
Now, it also says in the Act, Provincial Offences Procedures Act, that when a court date is scheduled for entering a plea or a first appearance on this matter, the Notice of Prosecution must be filed on the same day as the first hearing, the first court appearance.
So no later than that. Yes.
What we identified this afternoon is that no Notice of Prosecution is ever being filed for bylaw matters. It's all going in as a criminal offence by the laying of an information, which relates to section 6 of the first part of the Provincial Offences Procedures Act. It's nothing to do with tickets. We should not be having informations laid like a bylaw is a criminal charge. So
yes.
Basically that's a defect in proceedings, and it should be thrown out of court. Now, when Mr. Murray went in there, first of all we tried to say he's not well, because he is now suffering from depression and anxiety with all the stress and harassment of these hearings. They refused that completely and said if I tried to speak for him they would remove me from the court and I would not be allowed back in unless it was an issue of mine, which was pretty disgraceful, because in Court of Queen's Bench you're allowed a litigation guardian if you're not well.
Yes.
So it's not working. Provincial court, people are stressed, people are ill, people are under extreme pressure and duress. Most of them are innocent, and a lot of people can't speak for themselves, and when they start getting ill their mind seizes up. They can't think like a lawyer, they're not trained like a lawyer, sort of recall law and all that. Anyway, that was dismissed, so Andre Murray tried to speak to the judge and point out the defects in the documents, and she absolutely refused to hear them. He tried repeatedly to be heard, and bear in mind this is a hearing and a judge's job is to hear things, and the information Andre had should have actually said there's a defect in proceedings, what does the city have to say about this? But they didn't.
Yes.
They just basically said we're going to enter a plea on your behalf, not guilty, and you're going to be at trial, and when can you get his disclosure to him, and blah blah blah. And Mr. Murray asserted he wanted to be heard in respect of the defects in the documents. That's a serious matter when judges and lawyers and court personnel are taking the wrong forms and issuing people summonses and informations like they're criminals. And this is a bylaw issue, not wearing a helmet on a trail where there's no motorized vehicle, no danger. It's disgraceful. So I ended up having to witness Mr. Murray being removed from the courthouse for trying to speak to the judge by 2 sheriffs, and then being taken outside and surrounded by 4 sheriffs, and removed from the building.
And they literally dragged me out.
Yeah.
It was one on each arm dragging me out. It was not anything kind. It was physically dragging me out of the room. That is outrageous when all I was trying to do was actually just speak to the court. It's a hearing, you want to be heard, and it's a violation of the most basic legal premises of the right to be heard. Now, what's amazing is that the court did not seem to want to even allow me to point this out. I said, I'm willing to read the portions of the Provincial Procedures Act onto the record so you can see what I'm speaking of, and this is an incurable defect.
Yes.
This is, they cannot, like the Provincial Procedures Act allows for certain amounts of defects to just be waived, as in if it doesn't really matter too much, if little typos and things like that. But this is so big, it's huge. It's actually under the Provincial Procedures Act as an incurable defect, and the matter should just be tossed out for that.
I also witnessed somebody who has now been threatened with 4 days in prison for not paying a $50 parking fine. He was refused the possibility of paying in installments, which is why he ended up not appearing in court, and then it just became a huge thing. This is for somebody not putting a quarter in a parking meter. He's suddenly threatened in the mail with 4 days in prison. Is this really Fredericton that we want? I don't think so.
Yes.
And again, the wrong process, the wrong forms, everything was an abusive process by the very people who are supposed to enforce the law.
Yes. And with my matter, it was amazing because I tried to have the court just answer a simple question: is there a notice of prosecution before you? And she refused. Judge Mary Jane Richards refused to answer that question every time I posed it. I said, nothing more needs to be said right now. Let's just answer this question. If there's not a notice of prosecution, I need to know. I need to know today, because it has to be before the judge, like you said earlier, on at least by the day of the hearing, which is today.
Yes.
And if she had confirmed that there was no notice of prosecution, then right there it was grounds for dismissal of the whole matter.
That's a defect in proceedings, because the law says it has to be filed with the judge today, because today was the first scheduled hearing. And she didn't let you speak because she knew she was wrong to accept an information instead of a notice of prosecution for a bylaw ticket.
Yes. So, and the other thing was, the first threat was just to be quiet, and then it was be quiet or I'm going to hold you in contempt. And then it was, then I asserted myself, stating, listen, I need to be heard today. It's important that I'm on the record today, finding the simple information out. She kept talking over me, yelling, and then finally ordered the sheriffs to remove me. And when I continued to speak, as is my right, and I demanded to be heard, they physically put their arms on me, and two of them, one on either side, dragged me out of the courtroom. And then, like you said, 4 of the sheriffs ran through the hallway to surround me outside of the courtroom. Now that is outrageous, that all I'm trying to do is to be heard. It's a hearing, and I have the right to be heard, and they won't allow that to happen.
Yes. Well, as I have said before, and I blog stuff like this too on sites, the agenda here is, this is the way we, the establishment, have always done it. We've always got away with it. And now their problem is people are beginning to find out. Educated people who can stand up and speak and can write and can research the law are beginning to find out. Ordinary people as well who've just trusted the establishment are now beginning to see that when they get sucked into something like this, there's nothing reasonable about it, there's nothing just about it, and there's nothing lawful about it.
Yes.
So the agenda right now is they're confused because they've always done it wrong, and now they're being called on it and challenged on it, and they don't know what to do except be bullies and tell you to shut up and remove you from the courtroom.
And this is something even more in the bullying idea. Like, how did you feel when you saw me being dragged out of the courtroom?
I felt really bad. I couldn't do anything. I was ordered not to speak for you. I wasn't allowed to do anything. And I just found it such a degrading, offensive thing to do to an innocent person who is just trying to say, this is the truth. We shouldn't even be wasting the public's money in this courtroom because there is no case. You've done it wrong. It was a degrading, humiliating, horrible thing to have done to you.
And to see that now you're affected by it. That's You've just witnessed someone being terrorized by the courts whose job is to actually listen. They're supposed to hear people and decide objectively between the two parties who the court believes is in the right according to law. And they're not doing anything according to law. They're not actually hearing people. I mean, it's just ridiculous to not have the ability just to be heard at a hearing.
It sounds so simple.
Yeah.
It is simple. It should be simple. But we have one of the problems that I keep vocalizing is we've had our problems with the Fredericton City Police. They're ongoing. They're not going to stop because Barry McKnight's not there anymore. The Fredericton City Police Force is doing it the way they've been told to do it, which is wrong. The Crown Prosecution Services are not pre-charging, pre-screening cases. They're just saying, if the police say prosecute, we're going to prosecute. The judges are not evaluating cases and whether there's any merit to them. The judges, but they're all doing it the way they've been told to do it.
Yes.
There's something very rotten in the entire establishment, and I personally think it starts with the Law Society.
Yes.
The Law Society has the key politicians, and they have to be Law Society members. The Minister of Justice, the Attorney General, the Ombudsman, but not ex-Ombudsman, Law Society member, Chair of the New Brunswick Police Commission, Law Society member. To me, and judges, they're all ex-Law Society members. And in New Brunswick we've only got like 1,300 of them. It's a small pool, tightly knit brotherhood.
Yes.
And to me, they're the ones in control in this province.
Yes. All right. Any final thoughts?
I just want to say I'm disgusted. Not surprised, but disgusted.
All right. Thank you for that, Sally. I wish you a great day.
My pleasure. You too.
This is Justice Done Dirt Cheap in Fredericton, New Brunswick, Canada, at the Justice Building.